seated. Good afternoon. This is the time set for a public hearing on administrative docket number 0510, a petition to consider amendments to Nevada Rule of Appellate Procedure 3C. The court has received, to my knowledge, 2 written comments, and so we're anxious to hear oral input from those who wish to provide it. Unless there are any initial comments by Justice Cherry, I don't have any. Justice Cherry?
Just briefly, this issue comes down to whether or not there should be full briefing on cases where people have been convicted of felonies and gross misdemeanors and either sent to prison or put on probation. I think it's ironic that today I received a new case, a mechanics lien case. Opening brief, 58 pages. Answering brief, 57 pages. Reply brief, 30 pages. Over my 9 years being on this court, I've seen tremendous briefing in foreclosure mediation cases, employment security cases, water rights cases. And to not beat a dead horse, you should see what happens when we have a tax case for the indigent people who live in Tahoe. They fill our courtroom, and their briefs are incredible. There's never enough paper, as far as I'm concerned, in those cases. My colleagues, God bless them, they've been very good to me on my Indigent Defense Commission, going back to when Bill Maupin was Chief Justice and allowing me to maybe refine indigent defense in this community, in this state, to where we won national awards, and people have said, look what Nevada's done. They compare us to everybody with indigent defense, what we've done. We've got Drew Christensen and Bob Bell in Reno, and we've got great things that are happening with indigent defense. Yet we still have fast-track briefing on people who go to prison. I've heard many times from my colleagues, the briefs don't help. Well, if a brief doesn't help, imagine what a fast-track statement does. And to me, it's just an insult to the whole administration of criminal justice that we use fast-track. I went to our chief of our staff, Phaedra Kalecki. She and I have a good relationship, and I said to her, Phaedra, this was after we met with the Public Defender's Office, and Justice Gibbons and I were berated for the fact that we have fast-track, and went to Phaedra and said, if anybody wants full briefing, give them full briefing. And we have. I think we've accommodated everybody. And so all we're asking at this time, at least what I'm asking, is that we really take a look at whether we should even have fast-track. When we had we now have a Court of Appeals, and part of our pitch to the Court of Appeals was we would take a look at fast-track briefing. There were no promises, but we would take a look at it. So I'm hoping that, and of course the rumors start flying when I talk to my good friend Seth Floyd, who I thought would be presenting something on behalf of this new group that we have. We have these young lions and lionesses that are members of the appellate division of the State Bar of Nevada. These are young people. A lot of them work for us. Like the lady sitting in the audience now who worked for Justice Douglas, who become experts in appellate law. It's a specialty now. Steve, you know it's a specialty as far as the DA is concerned. It's much different when you argue as to what one of the young DAs argue. And they end up conceding issues and doing things that I say, oh my God, you'd have a heart attack sometimes if you heard some of your deputies. So that's my feeling. I'm hoping that, and one of the things I know, Phil, you're worried about is that you'll get dumped on. I don't think so, because anything that Drew's got, there's conflicts with the Public Defender's Office. You're not going to get those cases back. If Rick Wright or Bill Terry or any of the other people who are retained dump a case, I don't think it's going to go to the Public Defender's Office. These folks have retained counsel for the trial, and I think they'll probably retain counsel for appeals. And if they don't, so you'll pick up a couple cases. But I think that my experience, I was in the trenches just like you guys were. For a lot of years, I handled trials, and I always made sure there was somebody like Mark Bayless or some of my other associates over the years who would handle my appeals. And I just think that fast track is just a shortcut to injustice for the people that are convicted. And I had mentioned you, Seth. I remember I told them about our conversation about the new section of the State Bar, where we have young people like Seth in the future. Holly and Brittany will probably want to do appellate work. My clerks who want to do appellate work, and I think there's a lot of people that would even be willing to do pro bono work in the criminal area. So I'm on my high horse today. I've been looking forward to this hearing, and I'm hoping that my colleagues go along and we refine the system so that it's fair to the folks that are convicted and go to prison or get probation, and still being fair to Mr. Wolfson's office, Steve, and the rest of the appellate people in the DA's office who do a real good job. Whether it's fast track or our full briefing, Steve, you guys do good work. No doubt. That's it. I'm off my high horse.
Let's begin with any public comment in Carson City. Is there anybody in Carson City who would like to make public comment on this ADKT petition? Okay, apparently not. So we'll come to Las Vegas and begin here in Las Vegas. Anyone wishing to make public comment? Mr. Cohn?
Chief Justice, members of the court, my name is Phil Cohn. I am the public defender of Clark County. Obviously, Justice Cherry addressed some of the comments to me, and I think it's well meant. He is right. We had a CLE in our office exactly 2 years ago, and the comments were made by our office about fast track. And it's interesting that Justice Cherry mentions, one, we were complaining about fast track, and he certainly can appreciate that I'm going to be concerned about the resource issue. But both those things are true. I have been a critic of fast track. I admit that. I am very, very appreciative of this court taking a second look at it. To short circuit my comments, I absolutely agree with what the court's doing. I know there's people behind me who think we should go further or not as far as we're going in this ADKT discussion. But the idea of taking the A and B felonies, the most serious cases, the cases that most likely result in prison, hopefully, those are the ones that should get full briefing. And not just, in all fairness and all honesty, to this court, not just because we're making a record in this court, but we're making a record in A felonies for federal court. And if we're using fast track, I know we're not using fast track on A cases, but I think lawyers need to get used to making a good record, not just for the Nevada Appellate Court, not just for the Nevada Supreme Court, but certainly for fellow courts. And I think that fast track can make lawyers sloppy. And so the fact that we're going to try to look at a different way to do this for A and B felonies, I agree. I'm not sure I agree with only A and B felony trials. Because if there's an important discovery issue or Miranda issue or search issue that is litigated in district court, but the client decides not to go to trial, but preserves that issue for appeal, I'm not sure it should be fast track if you're looking at a significant time in a robbery with use case or whatever it be.
Mr. Cohn, I don't mean to interrupt you, but I am particularly interested in hearing from you, and I hope Mr. Owens will comment too, on the suggestion that has been made in the Washoe County Public Defender's letter on page 2 and footnote 2. And if you don't have that in mind, let me just repeat it. It deals with the issue of abolishing fast track, but setting aside a different briefing schedule for certain case types. And it goes like this. The rules of appellate procedure must provide a process for timely review and disposition of direct criminal cases, and perhaps some sort of modified fast-track system, or at least an amendment to NRAP 31, establishing a shortened briefing schedule for certain types of appeals. And in footnote 2, he talks about breaches of plea bargains, appeals involving restitution, appeals involving abuse of sentencing discretion, so that one wouldn't have a fast-track system, but the briefing period would be shortened for those types of appeals. So I was interested in hearing people comment about if we abolish fast track, are there still certain types of appeals that are amenable to reduced briefing?
Chief Justice, those are exactly the cases that I am worried about also, especially if we get a high volume of those from private attorneys who get out of the case, and then we're in that position of getting a high volume of cases that don't have a great deal of merit to the appeal, or aren't the kind of cases that when we talk about sentencing, that are often won, but are exactly the kind of cases that make clients angry. Because if they were made representations by a private attorney or by any attorney that were not realistic, those are exactly the cases that get them the most angry.
Are the cases that were listed by Mr. Petty and I just read, do you think they're still amenable to fast track disposition?
I do. I know others who disagree with me, but I do. Mm-hmm. I do.
So even if perhaps there was a change made in fast track that dealt with even A, B, C, D, and E felonies, if the subject matter of the appeal dealt with the subject matters that are covered in that footnote, it would seem like the concerns you would have would be mitigated. Because here's some numbers. The numbers are we get somewhere around 600 fast tracks. But probably a quarter of those are raising issues like I just read. And many of those are not coming out of your office. They're coming from conflict counsel and private counsel. Because somebody's just unhappy with the outcome of a plea deal.
Chief Justice, it's exactly the cases that I'm worried about that would cause us a great deal of concern that we don't have the resources if they're done with full briefing. And those are not the case. I completely agree with what Mr. Petty says. And that's why the only thing I don't agree with in the way the ADKT has been structured is if you have a very complicated, constitutional issue like I explained, sure. I think it should be, and I know that the court has been doing that anyway. I do understand. I don't mean to make this personal, Mr. Chief Justice, but we've had that discussion. Yeah. I know that the court is granting briefing on those cases. I think it would be good, as Justice Cherry has said, it would be good to have it as part of the rule. I would suggest that any time there is a constitutional issue or any important issue, that it should be full briefing in any A or B felony when you're talking about a significant time in prison.
Well, just to augment Justice Cherry's observations, I have always had a concern about conscripting criminal defense lawyers into appellate work. I mean, that's an issue, I think, that's a legitimate concern.
And I completely agree. I don't know how fast the court is going to move forward with this ADKT. My only concern is, like, how many, if we're talking about just the A or B cases that we're going to get from private counsel, I have tried to find out from the 8th Judicial, and we know from the Advisory Commission, it's very hard to get numbers out of the 8th Judicial. Yeah. I don't know exactly how many trials, jury trials they've had over the last, I was keeping track for a while. I know that it ranges between 160 and 190. Our office does slightly less than 50% of them. And I suspect that, so what you probably have about 40 trials a year done by private attorneys, and how many of those are we going to get? And the answer is, I don't know. And I think that I was hoping that that was something that Jamie or someone from the Supreme Court staff could look at. I've talked to John McCormick about it. Sure. I'd like to know how many cases, just so that when it comes time for budgeting, we can tell the county manager's office, hey, look, we think we're going to get this many more cases. We can try it for a year and see how it goes, see what we get. But mostly, I mean, all the discussions, Justice Cherry, that we've had on the Indigent Defense Commission now are geared towards the rurals, and that's what I'm most concerned about. If we pass a rule like this, and I do want the court to pass this rule, what is going to be the effect on the state public defender? What's going to happen in those counties where the state public defender does not exist. Someone does an A or B felony in Lander County. I can't remember what system they have in Lander County. Who is going to pay for the appeal? Who's going to do it? Because I agree with the Chief Justice. We should not be conscripting people to do appellate cases when they're not appellate lawyers. I loved doing trial work before I was an administrator. I really did, but I wasn't a good appellate lawyer. I enjoyed arguing before this court. I appreciate those opportunities, but I didn't like writing them, and I wasn't good at it. And I know there's a lot of lawyers like me, and there's lawyers who love doing appeals. And so I'm really worried, Justice Cherry, after all the discussions we've had with Lambros and the rules, what is going to happen in those smaller counties? What happens in Lincoln County when they get that big A felony? Who is going to do that if the lawyer doesn't want to do it? So I'm hoping that we can get...
I don't think you'll get those cases.
No, but I'm not speaking now as just Clark County Public Defender. Having been an engine defense, that commission, for the last 8 years and being a great opportunity, I know how this affects the rules. I haven't always worried about that. When I look at this, I want to make sure we have a rule that will either get it to the state public defender and augment their budget, or have someone who knows what they're doing in those smaller counties.
But if we could call it full briefing rather than fast track. You're right. One thing you said, and only people who practice criminal law know, that when you plead somebody guilty, you've talked to them, well, you got a chance for probation, and then they get hammered.
Yes.
They hate you.
Yes.
They hate you. And they want to appeal. And that doesn't mean you have to write a 30-page brief, though. In the old days, in the public defender's office, when I was the assistant public defender, everybody handled their own appeals. And what would happen is somebody would build up 5 or 6 appeals, and then they'd come into my office and say, I'm going into private practice, and I'd have to reassign the appeals. And I think that as long as there's an opportunity for full briefing, but also this whole idea of fast track, it just bothers me. The whole naming of it, called fast track. A small brief is just sometimes as powerful as a lengthy brief. You know, when I have to read a 58-page brief as compared to some of our briefs that are like 17, 18 pages, they're dynamic. They're great. They go right there. And the issue's right there for us to discuss in our conference after oral argument. And you have to admit that your appellate division, when Howard Brooks argues or Sharon argues or one of your appellate deputies argues, it looks better than somebody who's just, they don't have an idea. Now, Seth's got an organization now with this state bar where on some of these pro bono cases where they come forth, he did a family law case. He was fabulous. Boy, he had good training. His mentor's sitting here as the Chief Justice. And there's a lot of people like Seth and future people like Holly and Brittany and others that have gone through, that have been staff attorneys or have been law clerks, that appellate law is now a specialty. Steve can admit that. That's a specialty. Nobody does a better job in the DA's office than this guy. He's the best. When he comes forth, he usually gets what he wants, especially if he doesn't concede issues, which he rarely does. But I just don't like the idea of fast track. I wish we could work something out so that there'd just be, quote, quote, full briefing, but full briefing doesn't have to be 30 pages, and it certainly doesn't have to be 75 or 90 pages. So if we just abolish fast track, call it full briefing, and then you work with Drew. I want to hear what Drew has to say about the money thing, because he's right on top of it. And maybe even Seth will say some words, not representing anybody, but just as how he feels as a former law clerk who is trying to be an appellate specialist.
I don't disagree with anything you say. And again, it doesn't have to be full briefing. I mean, it's not be a long brief when it's just a matter, I didn't like the sentence. I understand that. But if we're going to do the job that I expect our office to do, it still means going to the prison, visiting with them, finding that out. It is time consuming. It's going to cost us resources. But I'm not saying no.
You still have to go see the guy. You still have to talk to the client.
Yes.
And then you have to make that decision as to should I file the motion with Ms. Galicki to see if we should have full briefing. I mean, that's like a waste. It's like a waste of having a rule that doesn't make any sense. And then I have to go to the CLE and say, now, if anybody feels they've been slighted by our staff, our criminal staff, please let me know. I've yet to receive a phone call, by the way. Thank goodness.
And I agree with that. Are there any questions of the court for me?
I interrupted your comments, Mr. Cohn. Were there some other points you wanted to make beyond what you were asked about?
No, I think this is a good rule. I think we should try it for a year, get an idea of what the resource drain is for our office. And again, I can't speak for the rules, but having been on that commission for a while, I am concerned about how we're going to address their issues when we have full briefing on every case or an A and B felonies, whatever the court decides.
Sure. Okay, well, thank you for the input.
And my question to you then would be, you would not be adverse to just repealing the rule entirely and see how it fares for the next year or so?
The answer is yes. I agree. Absolutely, I'm fine with that. I would like a little bit of lag time to go to the county because I think we're going to get a number more appeals, and I can sit down with your staff and work with that. This isn't the recessionary times of 6 or 7 years ago where I would have said, there's no chance in the world. I do believe...
Or even 2 years ago.
Pardon?
Or even 2 years ago.
Yes, or 2 years ago. I think the county is doing better. I would like to sit down with the 8th Judicial and with your staff and figure out, okay, how many more appeals are we going to get from private practitioners for doing that? And one thing I did forget was that Justice Cherry brought the idea of conflicts. Drew and I had that discussion today. There's a case that's going to get to this court very soon where it's a murder case. We did not have one party. We did have another party. We clearly cannot take that case. But there's some other conflicts when we get to appeal that we may have had to get off of a case earlier because we would have to cross-examine a witness. And if they're never called, I don't think I have a conflict in the appeal. So I think we're going to get more cases, Justice Cherry, than you probably think we're going to get. But I'm not saying don't do it. I'm just saying if this is a great idea, we do a little more research into how many cases Clark or Washoe is going to get, what's going to happen up in the rolls, and give me a chance to we get to the fiscal year, which is 6 months away, and do this. But I agree with Justice Cherry. It's time.
Okay, thank you.
Thank you.
Ms. Forza?
Just for the record, I'm one of the young lionesses on the
Good call.
The reference by Mr. Cohn to the federal court I think is important because the deference that's given to state courts is based upon an assumption that there's an adequate opportunity for appellate review. And I don't think anybody would call the reading of a fast-track statement an adequate opportunity for appellate review. What a lot of people don't understand is that the proposed amendment to the rule would actually add back in the life sentence cases to fast track. They weren't subject to fast track right now. I didn't realize it the first time I read it. But now you would have a case going through the system with a life sentence, maybe a pretrial issue, maybe a habitual offender issue, and that would be subject to fast track.
To be clear, the petition was initiated by myself and Justice Cherry to get the dialogue rolling.
Great.
So
Okay.
Just to be very clear about this, there's lots of permutations to this rule. So we just wanted to get it out there and get the conversation started as we, A, promised that we would, and B, feel that we should address. So I wouldn't read too much into the fact that the rule draft was limited to removing B felonies only from fast track and creating some other unintended consequences.
Okay, well that was actually one of our first, after our first point, which is that 3C should just be repealed. I wanted to address a couple of points under there that we put into our written comments. And I'm here representing NECJ, and I guess I'm representing private attorneys now, which is an odd position for me. But the conscription of private attorneys into doing one of the most important steps in an appellate process, which is identification of the issues for appeal, if that isn't gotten right, that case is going to fly under the radar, and you're not going to see it. And important issues are not just in A and B felonies. Sometimes the opportunity to address those comes up in lower level felonies. So I think the solution is to take all the cases out, let it shake itself out, and see what happens. But let me, as everyone was talking about the danger of, or as Phil was talking about, the danger of cases where the client is unhappy with the sentencing result. You told me I was going to get, believe me, I've had many of those clients. You told me I was going to get X, and I didn't. And so I want to take an appeal. The adverse effect of making that lawyer do the fast track statement is that lawyer cannot talk to the client about, the place for this is in post-conviction. That lawyer, the trial lawyer who the client is unhappy with, can't talk to the client about what issues he may have in post-conviction relief, because it's likely the issues he has are with regard to the lawyer who's talking to him. So it may be that once this shakes out after whatever modifications are made, is that you may have fewer cases because you've got a new lawyer coming in and saying, let's voluntarily dismiss this appeal and let's talk about what issues you may have on post-conviction relief. So our primary concerns are, first of all, allowing the lawyer to withdraw, allowing the trial lawyer to withdraw. I'll tell you recently what's happened when Rick Wright does the trial, is Rick Wright hires Frank Forsman to do the appeal. And the reason is that I'm an appellate specialist and he knows it. And I think that's who you want in front of you. Now, we're not quite there yet. You're still going to have a lot of people doing cases, and particularly in the criminal arena, who aren't appellate specialists. One of the resolutions that I suggest is if there is an influx of cases that wasn't expected or isn't adequately resourced in Clark County or Washoe County. I had a discussion with Jeremy Bosler about this, and he has talked with the state public defender. And why don't we look to putting some resources into the state PD's office? The lawyer doesn't have to be local to do the appeal. And developing some appellate expertise in the state PD's office to take the overflow rather than trying to jam them, to the extent there are some, into the different public defender's offices. So we really, if you don't just repeal 3C, our first request is
Ms.
that...
Forsman, before you leave that
Sure.
point, there's an important suggestion that has been made by Mr. Petty beyond the one that I mentioned to Mr. Cohn, which I would like you to comment about shortened briefing in certain types of cases. But one of the points that he makes, and I frankly had forgotten about it, but I think it's an important issue, and that is still requiring counsel to file the notice of appeal, at least, before they are allowed to withdraw. We end up with these Lozada problems.
I know, and I see them in federal court as well.
And that issue is a huge problem, especially for the public defender's office, who now comes in and it's, we run the risk of having the time run out and so on and so forth. It does seem to make sense that trial counsel would be expected to file the notice of appeal if requested by the client before they withdraw.
Well, in fact, that's what's included in our proposed amendments to the rule. However, it is what I think the public defenders are objecting to. But that was put in there actually at the request of the public defender for that purpose.
Phil can correct me if I'm wrong, but I think their objection is a fiscal objection, not a procedural objection.
It's a fiscal objection. We were sort of battling it out in the lobby, I have to tell you. But it's a fiscal objection because of an assumption that trial lawyers will file a notice of appeal even though there's no issues, and not attempt to talk to the client about the fact that there are no issues and you shouldn't be taking an appeal. So there's an assumption, and so I put that in there at the request of a public defender who had the same concern that Mr. Petty has, which is if you don't get somebody to file the notice of appeal, it's going to get lost. The appeal's not going to be filed. We have a Lozada appeal. Client says, I asked for an appeal. The notice of appeal never got filed. I know what we did in federal court where it looked like there was going to be a gap. The clerk filed the notice of appeal. And if the client was asking for an appeal, then the clerk filed the notice of appeal to at least save the time on it. So our first request is that you not expand the number of A and B felonies that will go into the fast track system with the proposal that's in ADKT 510, because A and B felonies that are pled or are resolved somehow short of trial with a denial or motion to suppress and then a plea with a conditional plea, restitution, as Mr. Petty points out, those kind of things, even if it's an A or B felony, now they will be subject to fast track treatment. We ask that you not do that, that you at least leave A and B felonies completely out of the fast track system. The second one is the permission to withdraw, which we've talked about. I don't think that lawyers just aren't, I think the original language was just unfair. It was talk to your governmental entities about increasing your pay if you're an appointed lawyer so that you can do these additional duties, or if you're retained counsel, get more money from your client to do the appeal. I just think that's unfair. Clients hire trial lawyers to do the trial. They don't necessarily hire that same lawyer to do the appeal. That just isn't the practice. And many, many lawyers who could get paid under the appointed system or under the retained system have another lawyer take the appeal because that's just not their skill set. And you see some of the briefs from lawyers where it isn't their skill set. And the third one is, as Justice Cherry mentioned, is the policy right now under this current administration, under this current court, under this current clerk, of if you ask to get out of the fast track and have full briefing, it will be granted. My experience is that happens. But why not codify it? Why not let the public know by looking at a rule that that's what's going to happen if you ask to opt out of the fast track system? It seems not right to me that procedure is not codified anywhere. It's just simply a matter of somebody talking to the clerk and saying, you can get full briefing if you ask for it. So that's, unless there are any other questions.
Well, just do one remaining question. How do you feel about Mr. Petty's suggestion that in certain appeal types, restitution, plea bargain abridgments, that there would be a reduced either word or page length? And I suppose he's not really talking about expediting the briefing schedule, but just the reduction of the size of the brief. I can see. He's also talking about shortened briefing periods, but instead of 120 days, maybe it's 60 years.
You have obviously even the current schedule for a very large trial, a long trial, isn't sufficient. But if you have a sentencing issue versus or a restitution issue, I can see that as a possibility, Your Honor. I haven't worked under a system like that because none of the federal appellate systems are like that, and we've never had a system like that where there were two different kinds. The only problems are going to be in things like motions to suppress, where you've got constitutional issues, and maybe you wouldn't put them on that list. But if in your appellate statement you said this is an appeal from a sentencing and we're raising an issue of bad imposition of the habitual offender statute or something, you might be able to do it.
Just using general numbers, and again, this isn't precise by any means, but there are some number of fast-track appeals currently where the issue is the district court judge didn't determine restitution and entered the judgment without resolving restitution. Well, and
that's the defendant who's taking the appeal on that?
Mm-hmm. Yeah. And they're saying, or the restitution was entered, and it's entered for an undocumented amount. That comes up fairly frequently.
Pay restitution, but we don't know how much it is.
Yeah,
or maybe no opportunity to contest restitution. So issues like that.
Right. And then there's another level of issues where, and more frequently, where the defendant says, I entered into a plea agreement and the plea deal said the state's going to keep quiet and there's either going to be a shortened prison sentence or there's going to be probation. And the defendant doesn't get either. They get a lengthy prison sentence, or lengthier anyway. That's a fairly sizable group of issues. And that's the only thing that's being talked about in the appeal. Quite a number of those cases.
Well, in those cases, I think you could do a shortened brief. A lot of times you're going to get Anders briefs on those, I'm assuming. Anders Sanchez briefs on those anyway.
We used to do that in the public defense officer where he actually said this brief is being filed under.
Well, we didn't file a lot of them. Part of this is communication with the client. Part of this is having a relationship. That's why I don't think that many retained lawyers are going to do this because it's easier to create that relationship with retained counsel. But and I do want to reemphasize the fact that I think we're at a stage where we need to start talking about appellate specialties, both for our appointed counsels. Certainly both public defenders' offices have done that to great benefit to the clients. I know that Drew has people who prefer to do appeals and are better at appeals that he appoints. And I think for the ones that are left over that are not covered by the two main offices and the two appointed counsel systems, that we probably could create a statewide appellate specialty. That is often done in other states, where you have a centralized state appellate office that has lawyers that's what they want to do.
Well, maybe somebody will once and for all bring forward the legal question about who is responsible for indigent defense.
The whole issue of state
county or
responsibility.
state,
Right.
but it certainly would be pretty apparent in this context.
Yeah.
One last thought about pleas of guilty that people are upset with. It's a good thing Santabello versus New York was full briefing. Because if that had been fast track, we wouldn't have Santabello versus New York.
You're right.
And a lot of times it's not the lawyers or the DA, it's the judge screws up the plea bargain. And that issue should be briefed. I just think it doesn't have to be a 30-page brief. It could maybe be 20.
That may be, that's
I
what
worry about when you
I
start
could
making
do.
exceptions. I'm more comfortable with the fact that Ms. Colicchio will give everybody full briefing if they ask for it and leave it to the attorneys. But we have to have Seth Floyd and people like that doing these doing these appeals. Not some guy who's never done an appeal.
I will recall for a minute my days with my law firm, and Rex Jemison and I are working very hard to file a 7-page reply brief in a Nevada power rate case. Because we felt that was the most effective way to present the argument.
It impresses a judge whenever I have something short.
Thank you, Your Honor.
Any other questions for Ms. Forsman? Okay, thank you very much for your input. Anyone else who would like to make public comment on this ADKT? Mr. Christensen.
Justice, this is Drew Christensen, Office of the Appointed Counsel with Clark County. I apologize for my appearance with no tie. I thought I was going to sit in the bleachers, but based on Justice Cherry's comments, I felt compelled to speak a little bit from where I sit and what I see. Our biggest hurdle, and I'll echo the comments from the two previous speakers, but the biggest hurdle I've seen from the private bar in the appointed context has been the fact that under the fast-track rules, it requires trial counsel's responsibility to exercise the fast-track statement. And many of our lawyers aren't, they're trial lawyers, they're not appellate lawyers. And so we've always tried to maintain that since we're in the appointed process, I try to mirror their representation as much as I can if they would have had institutional lawyers. And if you're in trial in the institutional office, regardless if it's Phil or anybody else in the office who takes the case to trial, it went to their appellate special unit. So it was a different attorney, same institutional office. But with the private bar, when they're appointed, they take a case to trial, but then we can't give it to another appointed attorney who may be more adept at appellate work. That trial counsel would have to perform the appeal. And many times, you spoke about a high number of fast-track briefs you see where the argument is, I didn't get a sentence that I thought I was to plead to. I see that a lot. The attorneys call me regularly asking, do I have to perform this appeal? I said, yes, you do. Well, the Clark County pays for the appellate work. We would just like to pay a different group, potentially, who are more appellate specialists. I know, unfortunately, I've sat in the bleachers in this courtroom before where you have order to show cause hearings. What happens to many of my attorneys is this example, and hopefully it may clear up some of your contempt orders that I've seen this court issue. There's a volume business to institutional work and appointed work, and I don't say that lightly, but there is a kind of assembly line. You take a non-life sentence, and a plea takes place. For all practical purposes, in that attorney's mind, that case is closed. I'm sure you see a lot of pro per notices of appeals. And then because you look for the last attorney of record, you send notice back to that track lawyer who wasn't aware that his client wanted to appeal. Luckily now the word's out, you've got to react to that and call me and I'll tell you how to walk through what your responsibilities are. But unfortunately some of the members, when they saw that, felt that it was a plea, there were no appellate issues, and got themselves in situations where they thought nothing. This court had to continually order briefing, and then unfortunately ended up where we sat here and listened to arguments on contempt. And I think the possibility of, I'll echo Justice Cherry's comments to get rid of fast track. But in any way, the Rule 3C, the part where it talks about trial counsel's responsibility, we institute, because life sentence cases are outside the fast track briefing, we have a policy in the appointed practice where at sentencing, we know if it's a trial, it's automatic, but if it was a plea and we get a feel that there's potentially an appeal, we have appellate counsel and trial counsel appear at the sentencing.
I was going to ask you about the time frame to.
So on the record, the trial counsel will perform the sentencing, and as soon as it's done, they'll move to withdraw. We have appellate counsel stand up, and so they know trial counsel is now off the responsibility of filing the notice. Appellate counsel get to meet the client, and they'll file the notice. Because as you made a comment, Chief Justice Hardesty, about should trial counsel always or in certain circumstances file a notice of appeal. Unfortunately, what I've seen happen many times is they do file a notice of appeal, want to get out, and there's a long process because district courts lost jurisdiction. They're not real comfortable with the whole appellate process of the Supreme Court in general because they're not appellate lawyers, and they're not comfortable with how to get out of a case to get somebody else involved. And if it's fast track, they can't get out. I mean, I've seen this court a few times because I see the appointments. I've appointed a few fast track appellate appointments, but not many because it's their responsibility to do the appeal. And so that's been my biggest hurdle over the last 8 years is that we have a lot of young lions who come in and, they're ready for trial, but they don't understand the consequences or they should, but they don't appreciate the dynamics of an appellate practice. It's much different. And the attorneys that I have that would like to do appellate work, I don't have that many to offer to them. Statistically, not that many cases go to trial. And then out of that subset of cases, there's not many life cases that go to trial. So when you're talking about the robberies and burglaries and even attempt murders and all that variety of cases that go to trial, but the term of imprisonment is a term of years, trial counsel's got to do it. So there's just not that many opportunities for the people who've requested appeals, have been qualified, have done appeals. I just can't give them that many.
How do you compensate your lawyers that are handling, how do you compensate the lawyers that are handling appellate work?
From the time the notice of appeal is filed, whether it's from a plea or trial, it doesn't matter. Clark County pays $100 per hour. If it's a non-capital case, $125 an hour for the reasonable and necessary work to handle the appeal, if it's a capital case.
Okay.
I think you just want to anecdotal, if I could, unless there were some questions. A few years ago, I thought this was an awkward question based on the fast track rules, and it made me feel uncomfortable that it was even being asked, but it should have been asked, given the context of the framework of the fast track. An individual pointed case was convicted of second-degree murder, and so the potential, obviously, was a term of years, a life sentence, and a variety of things that can happen with second-degree murder. The court called me and had concerns, didn't feel that a life sentence was appropriate, but I also wanted to make sure the defendant received full briefing because they thought there were some issues in the case. Now imagine that. If you're a court and your inclination and you feel it's in the best interest of the individual to have a term of years, I mean, it's still going to be 10 to 25 or 10 to life. But, obviously there's ramifications to either. But if you got 10 to life, you got full briefing. If you got 10 to 25, you got a fast track. Now, I assured the court, based on the comments from Justice Cherry, that we can make sure that full briefing can take place. There's a way to petition outside of the fast track. So don't give a life sentence just because you want to get full briefing. Isn't that an awkward? I mean, that's some of the unintended consequences, I think, of the difference between life sentences and non-life sentences. So, independent of your feelings on fast track, which I echo Justice Cherry's comments, I just like to be able to see what, echoing Ms. Forsman's comments about, let us have an appellate attorney, or at least someone who has a more comfort level with appellate work than the trial counsel. So
I wanted to take this opportunity because I've really never been able to thank you for the work you've done in creating the position of Office of Appointed Counsel. You do a great job. Thank you.
Justice Cherry. It's a work in progress. Obviously, we have some highs and lows, and there's hiccups and giddy-ups. But
It's nice to be an inventor, and you are. You've done a good job. Thank you so much.
Some questions?
Hiccups and giddy-ups. All right.
Chief, before the DAs, may I address one issue?
Yeah, sure, of course.
Philip Cohn again, for the record. Mr. Chief Justice, you asked Ms. Forsman about Mr. Petty's second comment about just filing the notice of appeal. That is the one area where Ms. Forsman and I sort of disagree because we don't know the mechanics of it. That's where I'm a little afraid of what Mr. Petty is recommending, because what my fear is, and maybe I have too low, I think Fannie tells me I have too low of regard for the bar, and if I do, I apologize for that. But I'm afraid that in every single case that private counsel withdraws from, wants to get out of after they've got a sentencing or something that went wrong, they're just going to file the notice of appeal, not talk to the client about it because things have gone south. There's going to be a notice of appeal filed and no communication with our office of where the ones are going to get them. So I don't know what the resolution is.
Well, procedurally, it is an issue, for the Supreme Court, it's particularly a problem because once the notice of appeal is filed, we have jurisdiction, but in many cases, the court has remanded to the district court for the appointment of counsel, so there's no immediate issue for your office, but there can be, for sure, and if the alternatives to the district court in appointing counsel are limited to the PD's office only, then that certainly could exacerbate the fiscal issues you're talking about. But the one thing I would observe, and this is not on you, Phil, or Jeremy, or the other PDs in the state. By the way, there's many, as you know, many rural counties now have their own contract or PD operations. The state PD's office only serves Carson City as we sit here today. So lots of these issues may not really exist in the rural counties, or at least what approaches are taken for Clark is going to be true with respect to the rest of the state. But it's really inappropriate for the state, primarily, or the county, to be relying on a fast-track system that has conscripted counsel into representing parties, and the state got off the hook of having to pay for them once they became indigent. As we know, a lot of these cases, the defendant becomes indigent after the judgment of conviction and the money runs out.
Chief, I couldn't agree with you more, and that's exactly what I'm only worried about the mechanics, and that's what Ms. Forstmann and I spoke about before we came in here. That's what we're concerned about. I don't have an easy answer for that, and especially in other counties. I realize Elko and a number of counties have developed public defenders, but I'm more worried in those counties that have a contract and don't have any kind of backup, and I don't know if that exists or not. We've looked at it, Justice Cherry. I don't know every system in all 17 counties, but I'm worried about that.
Well, actually, the contract system, according to the judges in White Pine as an example, in the 6th District has worked out, or 7th District, has worked out really well. So
Very few trials.
Very few trials, and so, I mean, the rural subcommittee's recommendations out of the Indigent Defense Commission has proved to be very successful.
And I'm very happy with the way it worked out. I'm only worried about the mechanics of once it's filed and how it gets to the next, if it's our agency or whatever other agency.
Sure.
That's what I'm worried about.
Yeah.
But I'm sure that's something that we can.
Well, I think it's important not to put the public defender's office in a fire drill, or a conflict counsel for that matter. Yeah.
How would you envision the transcript ordering and rough draft transcripts going if this rule were repealed?
Justice, that's exactly my concern. If someone files it, just files the motion, doesn't file the request for transcripts, doesn't file anything with successor counsel to give you some idea of what the concerns are, and if there's a relatively short time, or if we get a lot of cases and haven't had the resources generated to help us, that's exactly what I'm worried about. I'm worried. I know.
Because right now they're supposed to do the rough draft transcript requests same time as the notice of appeal.
And that's exactly my concern. If we don't keep that kind of responsibility with the trial counsel to at least let us, to put us on the right path.
Pass the baton fairly, yeah.
Yes. To do it in a reasonable way. That's my concern. Ms. Forstmann, I disagree. I think she gives more credit to the bar, and I think most people are deserving of that credit, but some people just walk away, and as this court sees all the time. That's my concern, Justice.
Okay.
And I've got one short suggestion to deal just with the issue of transfer.
Okay.
Thank you.
Thank you, Mr. Cohen. Were you finished? Okay. Okay.
Faced, this is Fran enforcement for the record, faced with this issue of what the Ninth Circuit refers to this as continuity of counsel, I don't have my finger on the number, but the Ninth Circuit has adopted a rule with regard to continuity of counsel and the responsibilities of the trial counsel in passing the case off to appellate counsel, because we were facing many of the same problems in the Ninth Circuit. So there's actually, the rule is all drafted out and probably could even be adopted wholesale.
Right. Thank you. Mr. Owens, did you want to comment on this particular docket?
Sure, I can weigh in. Steve Owens, Clark County DA's office. Probably have a little bit different perspective than everyone else who's spoken so far. I'm on the receiving end of all these appeals. I think there certainly is a place for some sort of expedited procedure for certain types of appeals. Certainly A and B jury trials has been in the court's proposal, exempting them for, if they've had a jury trial, exempting them from fast tracks. I don't see that as being a bad thing. I could go along with that. We've got C, D, and E felonies, and especially those where there was a plea of guilty. Their issues are going to be extraordinarily narrow, or their sentence so short. I found the Washoe County PD's filing very informative that I thought that hadn't occurred to me that many of them may expire their sentences before they have their appeal heard. So I know that the court has more resources now, and so it's perhaps inevitable that we'll be revisiting these fast track rules and deciding whether we really need them. I don't know how much more breathing room the court has. I'm a little nervous of just abolishing fast track altogether, and maybe we're right back into another backlog situation. I think there's a good number of appeals that where there's only one issue or a few issues from a guilty plea that don't need that full briefing. If there is, the rules right now allow for full briefing. Years ago, I used to oppose motions for excess pages or oppose motions for full briefing. I haven't opposed one in years now, and they're routinely granted for anyone who wants it, so I don't know that it's a problem. I disagree with the notion that longer briefs equates with higher quality. That has not been my experience. In fact, I have a team of 8 law clerks that write for me, and I have more time now to write some of my own stuff, but predominantly I'm reviewing their work and editing their work, and the more revisions we go through, the better the quality is, and especially if we can consolidate it down, focus on narrow issues, write more concisely, and that means redrafting and narrowing, shortening the length of the brief gets you more precise. And so one benefit, say what you want about the fast track rules, but one benefit of having 20 pages in the fast track statement is that it forced attorneys to look objectively at their issues and narrow them down and be concise and be specific. A well-written opening brief lends itself to a well-written answering brief. The opening brief is a mess. If we now have full briefing and an attorney feels obligated to meet some sort of indigent performance standard that I got to fill 30 pages regardless of how many issues I'm going to be attacked as ineffective later, then we're going to have this muddled mess of a brief, and I've got to respond to that, and my brief will be a mess because I'm trying to make sense out of what it is that they're saying, and they dance all over the place. So I think there's a benefit to having page limitation. I'm a little nervous of some sort of tacit adoption or recognition by this court through rulemaking that longer briefs equates with equality. Some of the worst briefs I've seen are the longest, where you just can't wrap your head around it. Some, either you folks or your staff, somebody's got to read all that and condense it down, shorten it down. What really are the issues? And those are some of my worst briefs, or the longest ones where I'm trying to respond to just a bunch of garbage that goes on for 100 pages. I can't wrap my head around it sometimes. So I just ask the court keep that in mind, that sometimes forcing the attorneys to be concise in their writing, and that there's a need for page limits, that generates, I think, a more higher quality brief writing. I think the rules are there now where anyone can opt out of the fast track procedures if they want. I think we ought to keep those at least as a default for guilty pleas, for C, Ds, and Es, and liberally grant full briefing if they want to, and see how it goes. As the rule reads, or the proposal reads, exempting A and B felony trials, I don't have numbers or stats, but I would think that is a good number of the appeals that we do. Most jury trials don't go on C, E, C, and D felonies exclusively. Usually there's at least one B in there. So I think just with this proposal of the court, we're going to see a lot more full briefs and very few fast tracks just for a few minor cases. And there's an avenue there where they can opt for full briefing if the issues warrant it. So I guess those are my comments. Judge Bonaventure Sr. used to have a practice in his courtroom when an attorney would go on and on and on and talk and ramble. He would point to a plaque that he had at his bench, and he says, "The truth takes but few words." And I think that holds true for appellate writing, too. I'm not a fan of the shotgun or kitchen sink approach where we throw every conceivable issue in there because we've got to preserve it all for federal review, and we're going to be called ineffective unless we've thrown everything out there. I think the court is benefited. I'm benefited when appellate counsel is more concise and narrow in their writing. Beyond that, I don't think I have much else to say on the issue.
I did have a question. What do you think about the issue of having trial counsel initiate at least the notice of appeal, or perhaps even request the transcript and then before they withdraw? I am worried about the delay that occurs. That's my biggest concern. If we get into all these Lozado problems, and I can see that happening. We already have those issues crop up where the defendant initiates their own notice of appeal and trial counsel doesn't know about it, and it's a huge delay.
Yeah. We have a much better rule now for dealing with the Lozada, the untimely or appeal deprivation claims. I think those can now be heard more quickly once they are identified. Certainly, anytime there's been a jury trial, I think there ought to be an automatic notice of appeal. And yeah, if the transcripts is the place where that's held up, make trial counsel order up those transcripts so we can get the ball going. I'm nervous of having an automatic notice of appeal every time there's a guilty plea. There may or may not be an issue there worthy of being entertained in appeal. Sometimes the client just needs to be told, no, what you really want is habeas. That's where you're going to get your relief. You want to attack your attorney. There's no remedy there on the appeal that's going to be granted to you. And I don't think trial counsel is going to have that conversation. I think they're just going to file the notice of appeal routinely in every guilty plea. And I've seen enough cruel and unusual punishment issues and fast tracks to last a lifetime. I'd like to see fewer of those. It doesn't bring us too much. I got a stock response, and we just file that, but boy, it's a lot of paperwork and a lot of frivolous appeals, primarily in guilty pleas where there's no meritorious issue, but somebody filed a notice of appeal, convinced the client that that's where what they need to do, and no one's able to talk them out of it, so we go forward with a frivolous appeal. But
it is awkward, though, for defense counsel to advise the client not to file the notice of appeal. Instead, you should sue me.
Well, we're not suing them. It's a conversation defense attorneys have.
I'm sure from the perspective of the lawyer who's given the advice, it's viewed differently.
I've heard it be said before, where defense attorneys have said, your next step is to challenge my ineffectiveness. I can't help you with that. You're going to need to do something else.
It's an awkward conversation. Anyway, I'm sorry, Mr. Rosenstein, for interrupting. Any other questions?
Mr. Owens, you mentioned you had 8 law clerks in your office working on these. How many deputies do you have working in the appellate department?
Well, that's gone up. Thanks to the Court of Appeals, we did get some significant help with that. It used to be pretty much me and one other person, and we do not just appeals, we do all the written habeas for our office.
So how many do you have now altogether?
Many of the habeas evidentiary hearings and arguments we do. But I've now got 5 attorneys, and so I'm no longer reviewing every appellate brief that comes through. Each 5 of those 5 attorneys gets to review their own work and do their own thing, and so that's helped
I'm sure Mr. Cohn's listening to these numbers here. Probably. My final question is, do any of your trial deputies in your office do their own appellate briefs, or does everything go through your department?
We've got one on DUI issues, just because he's most knowledgeable on DUI issues. I let him write his own appeals, and he understands them, his issues better than anyone else, but that's about it. We try to force the trial attorneys to go through a screening process with our appellate attorneys, and there's a lot of appeals you don't see because we cut them off and say, no, this is not a writ of mandamus we want to pursue. This is not an appeal that we want to pursue. We try to be very selective about what we do pursue, and it's been reviewed by an appellate attorney before we initiate a mandamus petition or an appeal, and we tend to write all those in my unit.
Great. Thank you.
Thanks.
Any other questions? Just speaking? Okay. All right. Yes, Mr. Floyd.
Thank you, Chief Justice. Justices, like Mr. Seth Floyd with the Urban Law Firm, also the chair of the appellate section. Like Mr. Christensen, I wasn't planning on speaking, but since Justice Cherry mentioned the section, I thought I would bring up one possible discrete issue where the section may actually be able to help, depending on how this rule is implemented. And I want to preface this by saying I'm not a criminal attorney. I think I learned everything I know about criminal appeals by standing outside for about 10 minutes listening to Ms. Forsman, Mr. Cohn, Mr. Christian, and Mr. Brooks talk about this issue. It was a pretty lively debate, actually. It was very, very interesting.
That's what the marshals said.
I think that Justice Cherry's right. There are, the appellate section, one of our missions when we formed 3 or 4 years ago was to try and improve appellate practice in Nevada. And one way to do that was to try and consolidate resources so that we could communicate with the court better, we could do better training, and we could provide opportunities for attorneys to get appellate experience. Because as a young lawyer, I can tell you, unless you're in the DA's or the PD's office, if you're a private counsel, it can be very difficult to get those opportunities. So I'm not here to talk about the philosophical question of whether this rule should be changed and whether certain cases should be subject to fast track or full briefing, but I am here to tell you that we have a very robust section and group of lawyers who would be willing to take cases if the opportunity presented itself. And like I said, I'm not sure what the mechanism would be for assigning those cases out. We have about 50 or 60 attorneys, I believe, right now who are actively involved in our pro bono program that the court assists legal aid in administering and assigning cases to. And there aren't enough appeals to go around for that program. I mean, I think every time there is a request for attorneys, there are 3 or 4 responses to each one, and of course only one person can get it. So if there are opportunities for more of those appeals, I think the section would certainly want to work with the court to try and assign those, and perhaps with Mr. Christensen's office as well, and maybe that's a conversation we should have offline if this passes. That's something we can talk about to try and get those cases assigned. So I just want to let the court know that there are attorneys available and out there that can assist to the extent that there are resource issues in the public defender's office in handling appeals.
And
100 or 120, well, 100 an hour is a lot better than pro bono.
Certainly, that's right.
I'm sorry, just Douglas.
Before you sit down, since you're the outsider looking in, that issue of continuity, as second counsel coming in, any thoughts? Or
So I think, the question, you were addressing the question with Ms. Forsman and Mr. Cohn about who should file the notice of appeal. I think the key link between the trial counsel and the appellate counsel, and this is what happens in civil practice too, is appellate counsel needs to be updated or instructed on what the potential issues are, and whether that happens before the notice of appeal is filed or after. That's the key link, because you certainly can't hand a new attorney a bunch of transcripts, particularly with a multi-day trial. I mean, these are long transcripts, and say, well, good luck finding those issues. Trial counsel can certainly be very useful in identifying those issues, which I think gives the appellate counsel a head start in addressing those on appeal.
And over the years, there have been some criminal attorneys who have taken cases pro bono appeals, high-profile cases. I know Jack Howard did a very big case, and some others over the years that had been under my tutelage at the public defender's office. Once they got into private practice, they saw some injustice in trials, and they took the appeals.
Yeah, and I will tell you, most of the appeals and Justice Pickering probably knows this as well as anyone knows, a lot of those appeals, I would say 75% of those are family law cases. So obviously this is a different area of law that attorneys can get experience in.
I just recall, at least in Washoe County, when I first started practicing, Judge Bowen called me up 2 months into the practice and said, "You're court appointed on an appeal for Freddie McRoy, second-degree murder." I said, "Judge, I'm into the practice 2 months." He said, "Do your best." Okay, thank you, Mr. Floyd. Any other question or any other public comment? All right. In Carson City, did anybody come in after we started the hearing that would like to make public comment? Okay, seeing no persons to speak there, we will close the public hearing and take the matter under advisement. Thank you very much for your input and